Well, staying with the commemoration of the day, as the world marks the 2024 International Human Rights Day, civil society organizations, international partners, as well as the private sector urging the government to partner with them in advancing the rights and protection of children in Nigeria. They are also calling on the governors of the remaining 11 states that are yet to adopt and domesticate the Child's Rights Act to do so.
With 18.3 million children of school age out of school, and 74% lacking basic literacy and numeracy skills, we are confronting a crisis that undermines the very foundation of our nation's future, and that is the truth. The attacks on schools and the resultant closures, particularly in the northeast and recently, sparsely in the southeast, have exacerbated these crises.
Well, the courts are in the news again, and priests in the Temple of Justice are once again divided on many issues. Well, one of the priests in the Temple of Justice is here to look at some of these issues. Afam Osigwe, the senior advocate of Nigeria and president Nigeria Bar Association, joins us in the studio. Good evening, Mr. Osigwe. Thanks for joining us
Good
tonight.
Evening, thanks for having me.
All right, we're celebrating International Human Rights Day. The theme is Our Rights, Our Future right now. I think that sort of highlights an immediate action to secure a just future. How does this resonate in Nigeria, looking at our legal judicial system, especially in light of some concerns that NBA has raised, misuse of remand orders, systemic rights violations? How does this resonate in our ecosystem?
Well, we have taken ourselves for primary focus, like you've noted, the issue of prolonged incarceration on account of remand orders issued by courts, especially the magistrate courts, in circumstances where the courts either have no jurisdiction or no charge has been filed. And we identify it as one of the major causes for the high number of prison inmates in Nigeria, which is put at about 73% of the prison population as being that of persons awaiting trial. And a number of these persons will never get tired of noting may spend longer time than they would spend if they were convicted. And some may actually be innocent. And like we noted, some get broken in the prison, lose their families, some get sick, some actually die while in detention. And again, we noted the fact that despite the provisions of the law, which require magistrates and judges to visit detention facilities, to ascertain the number of persons there, and also to inquire into their detention, either to grant them bail or that they be charged to court or that they be released on bail on certain conditions being fulfilled. Now, the magistrates and the judges are failing to carry out the statutory duty, and that has led to an increasing number of persons who have been imprisoned, who have been exploited, and so police stations have become a place of, and many detention facilities have become a place of gross human rights violations. And people are, even innocent persons, are only afraid of answering invitations to visit these places. And sometimes law enforcement agents use them as tools for exploitation. And I thought, and we believe that at the bar that we must focus attention on this, because any society that does not show that they can protect the rights of the people, cannot prevent them their rights from being abused, cannot protect their rights so that they can transform them, and the society may not be able to encourage the citizenry to achieve their full potential. And so we thought that for us to really achieve the theme of the International Human Rights, which is our rights, our future right now, that we must focus attention in this place, as well as some other areas that we need to focus attention. The administration of criminal justice in Nigeria, with some person, if the IGP a few days ago said it's broken and needs to be fixed, it needs to be revived. If the IGP, Inspector General of Police, could say that, and if the police has been found to be the biggest culprit in this, then it tells us how much work we need to do.
Great. First, congratulations on your election.
Thank you so very much.
Assuming the position as the NBA president, a lot falls on your shoulder at this time, and Nigerians are watching to see how you weave through all of this. But let me ask you, the judiciary is often said to be the last hope of the common man. From the things you have reeled out, it doesn't look like the judiciary is the last hope of the common man. You talked about weekend judges and magistrates, or on call like you have in the medical field. How exactly would that play out? How would that work? But let me also ask you, delays, allegations of corruption, lack of access to justice remain rampant. What is the NBA, particularly under your leadership, what are you planning to do differently to ensure that the judiciary is the last hope of the common man.
Well, despite the shortcomings, the judiciary remains the last hope of the common man, because most disputes will ultimately be adjudicated upon by the courts. But then, increasingly, the people are losing hope in the ability of the courts to do justice, and we have a lot of work to do, especially with respect to pre-trial detentions or prolonged detentions without any charge being filed, like I've mentioned, and also trying to reduce corrupt practices in the administration of justice system, whether among law enforcement agents, prosecutors, lawyers, or even judicial officers. So it's not a job for one person. An MBA cannot do it alone. We can draw attention to them. We can, through our various branches and our numerous members, embark on advocacy visit, deploy litigation as a tool, stakeholder engagement. But it's a multi-sectoral.
But you also have a disciplinary committee of the MBA.
Like all professions we do.
How effective has that been? Because some people say perhaps lawyers are part of the problems we have when it comes to ensuring human rights and the rule of law in the country, ensuring that Nigerians' rights are protected.
Well, I mean, I will not deny that lawyers may be involved, because some of the petitions that lead to some of these wrongful detentions are written by lawyers. But instead of keeping blaming ourselves, I think we should sit down, identify the problems, find solutions that work, institutionalize some of these things, ensure that right persons are appointed into judicial offices, ensure that where there are statutory provisions about what should be done, that they are done, ensure that persons, whether they be lawyers, prosecutors, or judicial officers who fail to abide by the provisions of these laws are seen out of the law, either as proof of corruption or proof of incompetence and inability to occupy the positions they hold. Because if a magistrate, for example, knows that the law says you cannot in the first instance remand the person for more than 14 days, and that the prosecutor must satisfy you that there is reason for the order to be made, and you merely sign an order without an affidavit being filed, without any application being argued, and you do that, then either you are incompetent or you have somewhat compromised your judicial oath of office and should not occupy that office without being sanctioned or seeing the way out. And if lawyers are seen to be involved in this, they too should be disciplined. But then nobody can be disciplined either by the requisite judicial body that disciplines judicial officers at the state level, the Judicial Service Committee, at the federal level for magistrates and area court judges, customary court judges, at the national level, the National Judicial Council, except petitions be written. And not just written, supported by credible evidence. You cannot by mere suspicion. But I believe that in some circumstances, the actions of the affected judicial officers should be enough proof as to whether that judicial officer should be sanctioned or not. And for lawyers, it goes the same way. And the body responsible for disciplining legal practitioners, that is the Legal Practitioner Disciplinary Committee, can do better, can do more. At the moment in Nigeria, it only sits in Abuja. And so all petitions from all over the federation have to come in Abuja. We have to look at the situation why we have to unbundle it and make it sit in states or regions so that these cases could go on faster. We have to speed up the disciplinary process, because the confidence the society has in the legal profession will continue to wane if we don't show ability to discipline the errant members of the profession. And so people should also be able to know that this is how to go about it. And the system must be seen to work and not be seen to be slow, or not be seen to act in such a way that it would appear that the aim is to protect lawyers and not protect lawyers from being disciplined, but to ensure that members of the public, either as clients or otherwise, who have suffered or who know about wrongdoing on the part of a lawyer, are able to get redress. We need to do all this.
Well, on the issue of focusing on what can help make our judiciary better, we've been talking about modernization of the courts, infrastructure, integration of technology in the judiciary. I know the MBA has some efforts in that. What are your thoughts on making that more of a strategy to better our judiciary?
I'm so glad you asked the question. When I was General Secretary of the MBA around 2014 to 2016, I became involved in what they call the Legal Mail project driven by the National Judicial Council. And it hasn't quite worked. My understanding of that project was that it was to integrate the entire superior courts, and so that e-filing and electronic filing of processes and service and even hearing could take place. And it hasn't kicked off. And this is 2024, for goodness sake. And sometimes people have to travel long distances to the appellate courts or trial courts for mere moving of motions. And I think our rules of court are not as forward-looking as they should be. The Supreme Court would appear to have pioneered that by amending and enacting the 2024 Supreme Court rules, which has provided for electronic filing. But the infrastructure for it is not in existence. And I believe, and I'm glad I'm using this platform to also talk about this publicly. The NJC can drive this process and make it compulsory that these processes work. And some courts that have introduced it, there have been complaints. For example, somebody talked about Lagos State. I said it is an archaic electronic filing system. It should be such that I should be able to file without having to scan documents or need any person to aid me. I should be able to do it, and the system should be able to assess the processes filed. And I pay online just the same way you pay for anything on a vendor site. We must get to that point where certain hearings can take place virtually. People don't need to travel. Tendering of evidence, we need to look at the Evidence Act. We need to deploy technology. If it's working in other places, it should work for us. And we could save a lot of money, cut out a lot of bureaucracy, red tapes. We could also cut out a lot of corruption that people intentionally engineer into systems so that they will be settled in the Nigerian way for things to move to the next place. We should also have an electronic way of assignment of cases in our courts. People don't have to keep visiting court registries to know whether their matter has been assigned to a judge. And it takes indeterminable length of time. There are a number of things that we can use technology to do to enhance access to justice, that even in some cases where people need to do pro se representation or need to represent themselves, they should also be able to do these things. Justice should not be very difficult for people to achieve. And if technology is working in 2024, and we are still talking about traveling from Maiduguri to come to the Supreme Court in Abuja to file a court process on a court of appeal, or even a court in Anambra State, hey, something needs to change.
Mr. Osigwe, we need to leave, but in 30 seconds, would you say Nigeria has made any meaningful progress at all in protecting human rights?
I would say we are making progress. I mean, the only thing that is constant in life is change. And we are making maybe not as meaningful, as appreciable as we would want it. But it's a work in progress, and we can do better than we are doing at the moment. And we cannot continue to make reference to it because it could be better than it is at the moment.
Thank you. Well, that's a fine place to leave it. Mr. Afam Osigwe is the president of the Nigerian Bar Association, the umbrella body of lawyers in Nigeria.